We are diving headfirst into one of the most fundamental and, frankly, commercially critical questions in contract law. What happens when one party invests a massive amount of capital, we're talking over $100,000 here, into a project, only to have the other side turn around and claim the resulting contract isn't even enforceable? Specifically because the investor, well, they seem to give themselves too many ways out.
That exact tension, between a huge investment and maybe uncertain legal promises,
Mhm.
that's right where the law of consideration and mutuality gets really interesting. Our focus today is navigating that tricky legal landscape. We'll be looking specifically at how the Texas Supreme Court handled this back in 1970. It's the case Texas Gas Utilities Company, VSA Barrett, and it deals with reconciling a major commercial investment with some very restrictive contract language.
Yeah, the stakes seem incredibly high and immediate in this one. A 5-year deal to supply gas for irrigation pumps. And that led the utility company's predecessor to build a whole 5-mile pipeline, costing, as you said, over $100,000. But then that huge outlay gets challenged because of just one single, very detailed clause aiming to limit liability.
An exculpatory clause.
Exactly. And that $100,000 pipeline investment, that's the concrete reliance we really need to keep front and center here. But before we can figure out if that investment was legally protected, we have to untangle the legal doctrines at play. We need to distinguish carefully between consideration and this idea of mutuality. They often get confused. Then we'll rigorously apply the rules the court used, using that essential FIROC structure for a deep analysis to the specific contract language they fought over. We'll see if the obligations were genuinely reciprocal or if the gas company's promise was, well, maybe just an illusion. Okay, let's tackle that core doctrinal puzzle first then. Courts often trot out this principle of mutuality of obligation, the idea that, quote, both parties to a contract must be bound or neither is bound. What's the...
It sounds simple, right? Fair is fair. A deal needs two committed parties. But believe it or not, this concept gets surprisingly murky when scholars and courts dig into what it really means for enforcing contracts today.
Okay, where does the murkiness come from? If both sides make promises, doesn't that just mean there's consideration? Isn't that enough?
It often is, yeah. But the big legal minds actually debate whether mutuality is even a necessary separate concept anymore. You have scholars like Williston suggesting that this whole mutuality requirement, it's basically just a different, maybe more confusing way of saying there has to be valid consideration. From his perspective, if you find good consideration on both sides, boom, mutuality is satisfied. It's almost redundant.
So why hang on to the term then, if it just adds another layer? Is it just, like, legal tradition?
Partly tradition, sure. But other thinkers, like Corbin, argue it still has a job to do. Corbin suggests we should use mutuality, really, just to talk about the idea that each party owes a legal duty to the other, that each one is an obliger. He agrees consideration is absolutely essential, the bedrock, but mutuality helps clarify those reciprocal duties. And then you have others, like Oliphant, who basically said, look, logically, you can't even connect the mutuality rule to consideration doctrine. He thought they were separate things.
That sounds pretty academic, that debate.
Mm.
But I can see how it would have huge real-world consequences, policy implications. If a court leans towards Williston's view that consideration is the main thing, it makes it harder for someone to get out of a deal just by vaguely claiming no mutuality. That sounds like a view that favors, protecting business deals.
Yeah.
Protecting reliance.
Oh, absolutely. It's fundamentally about protecting reliance and ensuring stability in commercial transactions. That's the policy driver. When a company sinks $100,000 into building something based on a contract, courts are generally going to look pretty hard to find an enforceable promise. They want to uphold that reliance if they possibly can.
Okay, so if we cut through the academic debate and focus on what a court needs to find to enforce the contract, what's the absolute bottom line?
The key takeaway, the bedrock requirement, is that the agreement has to represent an exchange of obligations of value, and these obligations need to be reciprocally or mutually induced. That exchange is what stops a promise from being illusory, from being empty. A promise only counts as consideration if the person making it is actually bound to do something or bound not to do something. If they keep an absolute right to just cancel whenever they want for any reason, well, that promise is illusory. No consideration there.
Got it. And that leads us perfectly into our test case. Let's see how the Texas Supreme Court wrestled with exactly this issue, especially with that huge investment hanging in the balance. We're turning now to Texas Gas Utilities Company, VSA Barrett. So using our 4X structure, let's start with the legally dispositive facts. What happened here?
Okay, so the petitioner, Texas Gas Utilities Company, sued the respondents, Barrett and some others. They were suing for minimum payments they claimed were due under a 5-year contract. The contract was for supplying natural gas to fuel irrigation water well pumps on the respondent's farm, which was pretty big, about 4,100 acres. And the contract had this minimum payment clause, $7.50 per 1,400 horsepower for each engine installed, regardless of whether they actually used that much gas.
Right. And what about the utility company side? This is where the big investment comes in, yes.
Correct. The petitioner's predecessor to fulfill this contract actually built a 5-mile pipeline. And the cost was explicitly noted as being in excess of $100,000, a major undertaking just for this deal. And crucially, during the time the dispute arose, the company stated natural gas was available at all times. They supplied it whenever the respondents ordered it. Despite all that, the respondents argued the contract couldn't be enforced. Their reason: lack of mutuality. And interestingly, the Intermediate Court, the Court of Civil Appeals, actually agreed with them. They initially voided the contract.
Wow. Okay, so why? What specific language did the respondents point to? How did they argue the gas company wasn't really bound, even after building that massive pipeline?
The whole fight really boiled down to one section, Article 6 of the contract. This was an exculpatory clause. And it contained some pretty strong language, including this phrase that the gas company assumes no obligation whatever regarding the quantity or quality of gas delivered hereunder or the continuity of service. ND. You can see why the respondents jumped on that. It sounds a lot like an illusory promise, right? We built the pipe, sure, but we're not promising anything about the gas itself.
Definitely sounds problematic.
Okay.
Framing our analysis then, what was the core legal issue the Supreme Court of Texas had to decide?
The precise issue was this. Did that specific exculpatory language in Article 6 make the entire contract unenforceable because it eliminated any real binding duty on the gas company? Did it destroy mutuality of obligation?
And what rule did the court apply to figure this out? How did they distinguish between a promise that's just limited versus one that's totally illusory?
The court went back to the fundamental rule we discussed. An agreement must be a binding and enforceable contract. It has to embody that exchange of obligations of value, reciprocally induced, valid consideration, essentially. So the critical question for the court became, did the language in Article 6 completely negate the underlying obligation to deliver gas, making it illusory? Or did it merely limit the company's liability if certain external things happened, like, say, an act of God or equipment failure?
Okay, this is the moment of truth then.
Yeah.
How did the court conduct its analysis? How did it read the contract to potentially save that $100,000 investment?
The Supreme Court did a really careful, close reading of the entire contract, not just Article 6 in a vacuum. And they found several distinct enforceable obligations that they believe survived that exculpatory clause. First, under Article 1, there was the basic promise, the obligation to actually deliver natural gas to the specified points on the farm unless they were prevented by one of the specific causes listed later in Article 6. Second, the court found the company had a duty to make reasonable provision to ensure a continuous supply. And they had to endeavor to supply the respondents' requirements. Those aren't guarantees, but they are duties. Third, the company was obligated to install the necessary metering equipment and, importantly, at its own expense.
Oh, I see. So even without an absolute guarantee of uninterrupted flow or specific quality, the court found these other concrete duties: a duty of reasonable effort, the infrastructure obligation.
Exactly. Those were seen as real value provided by the gas company. And on the other side, the respondents were clearly bound. They had to pay for the gas they actually used, and crucially, they had to pay those minimum charges. That was their consideration. So the court reasoned that Article 6 didn't wipe out the fundamental obligation to deliver gas, it just limited the scope of the guarantee. It meant the company wasn't promising perfect, uninterrupted supply no matter what.
That distinction feels like everything here. But if they didn't guarantee continuity, how is the promise still, non-illusory? What teeth did it actually have?
Great question. The key is this. The company would still be liable for breach of contract if it failed to provide gas for reasons other than those specifically listed in Article 6 exculpatory list. So, for example, if the gas company just decided one day, we don't feel like supplying Barrett today, even with Article 6, that would likely be a breach. Why? Because not feeling like it wasn't one of the listed excuses, like acts of God, strikes, necessary repairs, etc. Plus, there was another layer. As a public utility, the company was also subject to state law, specifically Article 6057 of the Texas statutes at the time. That law imposed a baseline duty on gas utilities to provide service if gas was available. So this external regulation has sort of reinforced the idea that the company's promise wasn't just empty air, it wasn't truly nothing.
That's a really detailed analysis. It really shows the court working hard to prevent one potentially poorly drafted clause from destroying what was clearly intended as a major long-term commercial arrangement.
Just to push on this slightly, what if the contract had said something different? Like, the gas company reserves the absolute right to terminate this contract and cease all service at any time for any reason whatsoever, just by giving written notice. Would that have been illusory?
Oh, absolutely, yes. That kind of clause, that grants an unfettered absolute right to just walk away from the deal. It makes the promise to deliver gas essentially meaningless, an illusion, no real commitment there. The crucial difference in Texas gas utilities was that Article 6 didn't give them a blank check to walk away. It only listed specific, largely external reasons that would excuse non-performance. That's why it was seen as a limitation on liability, not a total negation of the core duty.
Understood. Okay, so wrapping up the case then, what was the final conclusion? The final conclusion was that the contract was enforceable against the respondents, Barrett et al. The court found that mutually binding obligations were present. The exculpatory language in Article 6 didn't destroy the company's basic obligation to deliver gas, it just defined the conditions under which they wouldn't be liable for interruptions. So the lower court judgments, which had voided the contract, were reversed.
Okay, we've seen just how critical that line is between limiting liability and actually negating the promise itself. It saved a $100,000 pipeline investment here. Let's try to synthesize this. For you listening, if you're reviewing a contract or maybe even facing an exam question on this, how do you test if an escape clause like Article 6 actually kills the consideration or mutuality? Can we make a checklist?
Yes, let's build a practical, step-by-step diagnostic checklist straight from the logic in Texas gas utilities. Think of this as your contract survival checklist for these kinds of clauses. Step 1, check for reciprocal obligation. First things first. Did the agreement actually contain an exchange of obligations that have value? Were they mutually induced? You've got to pinpoint what each side actually promised to do or not do. If one side's promise is clearly empty, they aren't bound to anything real, you might stop right there. No consideration. Step 2, locate the alleged out. Find the specific language that someone is claiming lets one party off the hook. Is it an exculpatory clause, like in Texas gas, a termination for convenience clause, a subject to financing clause? Pinpoint the potential problem area. Step 3, analyze the scope of the out. This is critical. Ask, does this clause give the party complete, absolute power to just walk away for any reason or no reason at all? If yes, the promise is almost certainly illusory and the contract probably fails for lack of consideration.
Yeah.
Or does the clause merely limit liability or excuse performance based on specific, usually external conditions? Things like acts of God, riots, material shortages, government actions, necessary repairs, things often outside the party's direct control. Step 4, apply the Texas gas test. Here's the payoff. If the party with the supposed out would still be legally obligated to perform, if the failure occurred for reasons not listed in that exculpatory or limiting clause, then the core promise likely still exists. The obligation is real, just qualified. In that case, the clause acts more like a potential defense against a claim of breach under specific circumstances, rather than proof that there was never a binding promise to begin with. If the obligation exists outside the specified exceptions, the contract is likely enforceable.
That's a really clear framework.
Yeah.
So thinking about the real world, the commercial reality, it really hammers home how careful you have to be with drafting these clauses. A subtle shift in wording, from listing specific narrow defenses to reserving broad discretionary power. That's the difference between protecting that huge $100,000 investment and potentially having the whole deal collapse.
Precisely. It's about making sure your limitations are clearly defined defenses against breach under specific, often extraordinary conditions, rather than language that fundamentally undermines the very existence of your obligation to perform in the first place. The Texas court, fundamentally, wasn't going to let the gas company have it both ways, collect those minimum payments, while effectively promising nothing concrete in return. They read the contract to find a meaningful, albeit limited, duty.
We've certainly unpacked a lot of nuance around mutuality and consideration today. It really boils down to needing that non-illusory exchange of value, especially when significant reliance, like building a pipeline, is involved. Thanks for walking us through this essential concept.
My pleasure. And maybe a final thought for you to mull over. In today's really complex global supply chains, contracts are often layered with multiple clauses limiting liability or excusing performance for various reasons. At what point does the sheer number of specific allowed excuses start to make an overall promise feel, well, functionally illusory, even if no single clause grants absolute discretion? The lesson from Texas Gas Utilities seems to be that clarity and limitation are key, but there might be a tipping point, something to think about.